Welcome back. Well, we are supposedly minutes away from the ruling on the mistrial motion that was put forth by the defense. Let me tell you what's going on outside the courtroom right now. Michael Christian, our field producer, is saying that it's a beehive of activity outside the courtroom, and he took some observations of both the defense team and the prosecution team. He says of the defense, I can see through the courtroom door that many of them are sitting inside already. They're assembled at the table. The prosecution's gathered together in another courtroom, and he says, my immediate impression was that they all looked pretty glum. Now we're learning that Kathy Patton has made her way into the courtroom. She is the prosecutor who started a lot of this fervor through her redirect examination of Tom Pantinelli. So the judge soon should be in there, and we'll hear what his decision is. I want to bring our team back, in-session correspondent Gene Casares. We've also got Karen Conti with us, Brian Claypool, and Judge Stephen White. I want to start with you, Gene. You were in that courtroom hearing much of this arguments surrounding the mistrial motion. Give us an idea of the state of mind of Judge Edward Burmilla at this point.
Right, and I think that's important. Now, let us say that when the U.S. Supreme Court heard argument on Obama's health care, I think a lot of people believed it was going to be found unconstitutional based on what the justices said, and in the end it was not. But I think it's important to look at the state of mind of the judge before he broke for lunch. When he got to this point, he called it an incident, and he's talking about the bullet. He said, it is completely troubling to me. I have to say that the argument makes no sense by the prosecution at all. To put a witness on, to give a reason of why a witness was intimidated, but the reason for intimidation was completely unreasonable. Because it's only one of two things that a juror can deduce from this. If the defendant put the bullet in the driveway, but yet he denied it, the real intent is to kill your neighbor. And who's the only one that had a gun around there that we know of? Drew Peterson. Who's the one who would want to kill Drew Peterson? Versus prosecution, you're saying our witness has no credibility. He was wrong. So you can't believe anything he has to say. It was completely unsupported by any evidence, and you gave a specific question to elicit that answer. And that's when he said, I'll take it under advisement, be back at 1:15.
Interesting. So, Gene, let me make sure I have this right, just so I understand. The reason for intimidation is unreasonable because the assumption would be that putting that bullet on the driveway would be an assumption that Drew Peterson wanted to kill Tom Pantinelli?
Not the reason for intimidation is unreasonable, but the reason the prosecution was trying to elicit it to show why he was intimidated. That was unreasonable because there's no bearing in fact, there's no evidence you can link it up to, and either you're saying that Drew Peterson was trying to kill the next door neighbor and that's what the bullet was symbolic of, or our witness up there, you can't believe anything he has testified to because he doesn't really know. That's what the judge was saying.
Okay. Karen Conti, what do you think about that?
Well, I think just the average layperson is going to say to themselves, if a person puts a bullet in a driveway to a neighbor to tell him not to fix locks on a door of a soon-to-be ex-wife, what would he do to his ex-wife? I mean, it shows his violent tendencies. It shows how angry he was. It shows how bitter he was. It shows how he wanted Kathleen Savio to have it in for her. I think that's what I would think sitting there. Who does that kind of stuff besides somebody who's violent and intending to harm somebody? Yeah. That's common sense.
It's a good point. So, Brian, I know you were talking about maybe the line of questioning and everything that happened after that wasn't enough for a mistrial. But what do you think, hearing that context as well from the judge in terms of his state of mind?
Well, I think the judge's comments are kind of a camera through which we can see what he's thinking. Yeah. And it looks like he might be leaning toward declaring a mistrial, but I'm not so sure of that still. And here's why. Ask yourself this. Why didn't the judge then preempt this from happening? In other words, he knew about the pretrial ruling, right, that's supposed to be excluding this kind of questioning. You hear a question asked by the prosecutor. You have to know, as the judge sitting in that chair, where this is headed and what a potentially devastating answer might be elicited from that question. Why didn't the judge say, hold on, everybody, let's have a sidebar, pull these lawyers off to the side and say, What are you doing, Miss Prosecutor? Why are you asking this? Aren't you violating an in limine order? You need to withdraw that question and let's move on. Why didn't the judge do that? Number one. Number two, why didn't the defense lawyers for Peterson jump up and argue irrelevant? Why wasn't there any objections here about relevancy? And I think your contributor judge will also agree with this, that even if evidence is deemed relevant, there's also an evidence code that says if it's prejudicial and the prejudice outweighs the relevance, it's still excluded. So these are two other options that could have been invoked to preempt this entire problem, and they should have been.
Yeah, two good options. So, Judge White, let me ask you, would you, as a judge, have, as Brian said, jumped in and tried to preempt that from happening?
Well, as a judge, you don't want to step in on the attorneys too soon, because then it looks like you might be taking one side over the other. So you kind of let the lawyers, because what if the defense wanted to let him answer that question to see what it was, and you don't know that, so you're kind of leery to step in and like impose an objection before there's an objection from the opposite side. He is right. I mean, the standard in Illinois is, does the probative value, is that outweighed by the prejudicial value of the question or the item that they're trying to get into evidence? And that's that. You know, he's also viewing that right now before he makes his decision. But it's rare that a judge will impose an objection for one side or the other. He wants both of these sides to try their own case.
Yeah, I could see that too. Although I have to say, in line with what Brian was saying, I still would have expected the defense possibly to jump up. But see, at least we know where the judge is coming from on this. And I think Gene was really right. That's going to give us an important implication on where he might go. Now, I just want to read from Michael Christian, by the way, who is gathering around that courtroom. People are getting ready to go in. He says there are more people in the overflow courtroom than they had recently. Let's see. Everybody basically, his point is everybody is basically gathering to hear Judge Burmilla's ruling firsthand. The court is a little more crowded than normal because people, I think, are sensing this is a very big moment coming up. And, Gene, I got to say, there are so many different interpretations of what the judge could do right now, Gene. But I got to say, based on what you're saying on the state of mind, I would be stunned to see him backtrack and say, yeah, I thought about it, and even though I made those comments about where I was coming from on all this, no, I'm not going to go for the mistrial. What do you think?
It does happen, though. I mean, he's cooled down, he's reviewed the case law, and he definitely could just decide to strike the testimony in total, have an instruction to the jury. But his state of mind at that moment before he called the recess was definitely in one direction, no question about it. But I do want to say, since I was sitting in that courtroom, and I did not know that there was a bullet found in the driveway. I was not present for the hearsay hearing, but I thought that it was going to end with, yeah, I felt intimidated. We had a conversation about the locks. He told me he didn't want me to put any locks in her front door or locks around any doors, and I felt intimidated. I thought it was going to end there. And I thought, okay, all right. And then it went on. And then it just all of a sudden, boom, it came out. And I was as shocked as everybody was in that courtroom.
Yeah. I mean, it's just shocking to even hear it. And Judge Stephen White, there's another aspect to this as well. Once we hear the prosecutor, as Gene said, talk about, yes, I did want to talk about this. I did want it to come out. And then I was going to follow up with questions about whether or not you knew for a fact that that was Drew Peterson who placed that bullet there. The witness was going to say no. And that was going to come out. The question I want to ask you is, for a jury member, again, we were talking earlier about unringing a bell. So the information is out there and the prosecutor says, well, I was going to ask and kind of dial back on that to set the context for the jurors. But do you as a judge worry that if that's part of the strategy that you allow to happen for a prosecutor, that they might continue to do that? They might continue to push the line too far and then say, oh, you know what, but I was also going to surround that with context. It's kind of like planting the seeds, but then being able to ask the questions afterwards to say, oh, yeah, I didn't really want to plant that kind of seed, but maybe you thought you really did want to do it that way.
Well, I think that's why, you know, when he was saying these words before he took a break, he's trying to communicate to the state that you're treading on dangerous waters, and if you keep it up, you know, the consequences could be severe on your end. You know, another thing is you know, jurors sit there, and I think I said this the other day, they have preconceived notions about what the defense team will do and what the state will do. And there's a preconceived notion by most people that the state is going to play this game fair, and they're going to go after them with everything they got, but they're going to play the game fair. The more times that a judge sits there and tells them they must disregard something that the state put on, that can have an adverse effect upon a jury as how they perceive what the state is doing.
Very interesting.